introduce our next speaker, Cindy Ellis. She is going to be talking to you about getting your clients prepared for the courtroom. Cindy is a Davie County resident, lifelong Davie County resident. She is the only Davie County attorney currently on the capital defender roster, and she has completed court in many different areas. And she has done civil cases, custody cases, abuse neglect court, juvenile delinquency cases, superior court cases, across the board has been working on a number of things, and I think doing some appellate work now as well. So without further ado, I'm going to turn it over to her. She can get started. If you need the microphone, I don't think it's actually working, but there you go.
Okay. Can everybody hear me? Yes. I'll try to be loud. So, y'all heard a lot of technical stuff about juvenile court and about murder this morning. I'm going to talk to you a little bit more about interacting with your child. That is ultimately the hardest part of this job. We all know how to file motions. We all know how to pick a jury. Some of us do. But at the end of the day, you're dealing with a child, and they're not like adults. You've heard it hundreds of times. So the first thing is whether your child comes to court. Almost every county that I've practiced juvenile delinquency in, got a prosecutor and a judge and a court counselor who all say, we're going to do that by WebEx. No, we're not. My child hadn't consented to being on WebEx. 2, there's no way for me to communicate with him. I know they tell you that there is, and WebEx prides themselves on that, but there's no way for you to fully and confidentially communicate with your criminal when he is on WebEx. He needs to be in the courtroom. That is my policy. Now, if this is the 5th or 6th or 20th time this child has been on for secure custody hearings, or for the state to come in and say, we're not ready on probable cause for the 100th time, then that's different. You've had plenty of opportunities to talk to your child. They know what's going to happen. I don't know that they can ever knowingly, intelligently, and voluntarily waive their right to be in court, but they kind of know nothing's going to happen. They're not going to miss anything. And then I think you're in a different situation. But generally speaking, the first handful of times court is in session, your child needs to be there, not on WebEx. Dealing with your child's expectations versus realities. This is when you get to superior court on a first-degree murder with a child, they're going to tell you the same things juveniles tell you when you're in delinquency court in front of a district court judge. Nobody's going to show up to testify against me. Those are my people. They're not coming. You're going to hear it. You're going to hear it more than you ever imagined. They're going to tell you that. They're going to tell you things like, they don't have any evidence against me. There's nothing against me. And then there's the reality of it, which is your people are going to show up because the state's going to issue a subpoena, and they're going to have an officer go to that child's house and pick them up and bring them to court. That's going to happen, especially on a murder. Of course, you're going to get those witnesses there. That's what they do. You're also going to have to explain to sometimes a very young, very immature, very confused child the difference in circumstantial evidence and direct evidence. There are adult defendants that are successful people for them. They hold down jobs, they have homes, they have families, they have children. They're doing things right that still don't understand the difference between direct evidence and circumstantial evidence. It is a hard thing to explain to children. They don't understand a lot of things that are happening in superior court. They don't understand a lot of things that are happening with them at that exact moment. But direct and circumstantial evidence, along with the felony murder rule, are 2 of the hardest things to get children to understand. They may not have the murder weapon. They may not. That the people might not show up. We'll give them the benefit of the doubt. Your people are not going to show up to testify against you. But what do they have? They've got you in the proximity because you had your phone with you. They've got surveillance cameras from the apartment complex where you were hanging out 10 minutes before whatever happened where someone died. They've got your fight last week at school with the victim in the hallway that's on camera, that school resource officer stuff. You have to explain to a child that all those things, whether they show directly that he had something to do with this homicide, it's going to make a jury think you did it. And that's a hard thing to convince a child of. It's hard to convince a child that anything bad is going to come from their behavior because they don't think that far ahead. I mean, we've heard a lot about brain development, and there's a ton of evidence out there about those types of things. And anybody who has children know that you know that your child just did something wrong. They know that you know. And when you ask them, they'll still swear, no, I didn't do that. Like, how did this end up outside? Oh, I didn't leave that outside. But I saw you outside with it. I didn't do it. It's the nature of children. They'll try you. So then once you go through all these things and explain what they expect is going to happen versus what really is going to happen in a courtroom, then you have to say, okay, the state's making you an offer. The hardest part, I think, of our job is explaining to someone how good an offer is, because that's what you hear. What are my chances? Like, give me a number, 50-50. Like, they want a percentage. How likely is a jury to convict? Anybody who's done any trial practice knows jury's very, very likely to convict you. It doesn't matter what the evidence is. I mean, 12 people that do not understand reasonable doubt are probably going to say you did this because the state says you did. They charged you with it. We're here. If you didn't do it, it'd probably been gone away by now. So we're here, so you're probably guilty. So when you get a decent offer, which still happens from time to time, you get a decent plea offer, you have to explain to a child what that looks like. And with adults, it's very common. Okay, I can do, we've all heard it. I can do a couple years. It won't be bad. I can do a couple years in prison. I can do bottom of the mitigated. I'll second. That's what I'll do. I'll do 12. And you're like, okay, well, you're level 5, so that's not 12 for you. But children think about things, and you say they're offering you, for example, they're offering you 15 years for this murder. They want you to do 15 years active. 15 years to a 15-year-old or to a 16-year-old doesn't even register. Like, so what does that mean? I mean, and bless our education system, some of them have to ask you, how old am I going to be when I get out? Are they all plus 15? But it happens a lot. These kids want to know things like, will I be like old? Will I still be able to, have kids and stuff? I don't know what they think happens when you turn 30, but
You die.
it's things like that.
You
Like,
die.
well, I did have one juvenile ask me one time, am I going to be old like you? And I was like, oh, that old first. Then immediately got some more Botox. I was like, this is not working. So the next thing, you get an offer, you have to take it to your client. We're obligated to present all offers to our clients. But then with kids, you have another element. You have family. You have family. There's two kinds of family, in my experience. The ones who any time is too much time, or let him out and I'm gonna fix him when I get him home. I'll get him right. You won't ever have to worry about this again. And usually the state is not fond of either one of those plans. That is not what they want to happen. So you have to figure out what relative is going to be the most influential in communicating reasonably with your client. And I say reasonably because juveniles are not reasonable. They do not think. If they were reasonable, we wouldn't have a first-degree murder training for juveniles because they're not reasonable. They don't think about the things that they're doing and where that's going to end them up. So you find that relative, and you tell them, this is the offer. I think it's a fair offer or it's a decent offer. They're rarely good offers, so I don't say that often. But it's hard to, with the great case law that's come that says we cannot sentence juveniles to life without parole. We can't keep them in prison forever. There's some really good opportunities to negotiate because you can go to the state and say, you can't do this much time. So let's come down here to this much time. But kids want to get out now. I mean, they sob hysterically after secure custody for 10 days. I mean, why can't I go home to my mama? Well, you should have sat home with your mama and we wouldn't have been here. But evaluating those offers are very tough. Kids they want a number. They want to know, how likely am I to be convicted? Do I have to say I did this? Do I have to implicate my friends? There's a lot of issues that are going to come with a C offer that kids are way more interested in than adults. They don't want to tell on anybody. They don't want to have to truly say that they did anything wrong. I don't know why that becomes such a hang up, but they definitely like those guilty pleas to Alfred and no contest pleas. They like to admit to their problems that way. But sometimes those aren't options for plea offers. So you have to really nail down what the state is going to ask for from this juvenile and then communicate it to his family and to him or her in an appropriate way. Anybody, who's on the capital list in here? Okay, so we have a lot of y'all. I know you've heard people at the Capitol Defender's Office tell you, your defendant's mama is usually the person that's going to make or break everything you try to do. Other mamas are your best friend or your worst enemy. They're going to help you resolve this case and save somebody's life, or they are going to tank it. It is no different with children. It is absolutely the exact same thing. Generally speaking, juveniles listen to their mama. Just like adult defendants, mama usually has a lot of pull. Sometimes that's not the case. Sometimes it's just had a case in Forsyth County with a juvenile whose sister, who's only 9.5 months older than him, is the go-to. What she says is what he does. Going to do an admission, got to talk to her. Going to have to go to Eckerd, got to talk to her. Every decision had to go through his barely older than him sister. So every family dynamic is a little different. You have parents that do not like each other. They're not together anymore. And dad says, you need to take responsibility. You need to take this deal. You need to be done with it. Mama says, my baby didn't do anything. He's not going to prison. And you have to figure out how to manage both of these people and a client who doesn't understand why either one of them are saying what they're saying. And that's sometimes the hardest part of managing your client's expectations is managing his family's expectations. What are you doing? How can you fix it? A lot of times one parent will think you're doing a great job. The other parent thinks you're terrible. You've done nothing for their baby. They're sitting in custody and here you have come at me with this second degree offer. What are you doing? And what is the state even paying you for? And that's when you say, well, they're not. Not yet. I need to read one day though. Then the next thing you need to do is set up your client's team. Your team is his family, his friends, siblings. Sometimes there's an aunt, sometimes there's grandparents. Every once in a while, you'll have a juvenile that has outstanding support in a non-traditional place. You'll have a school resource officer that thinks your kid is great. You'll have a basketball coach that's had a relationship with him for 10 years. Can't believe he's got himself into this. Sometimes there's just random teachers, neighbors, all the things these kids have been involved in all their life. Those people know great things about your client. Much better things than you do. And the things that right now, while mama is furious that he's been put in custody for something, she's not going to tell you all those things. But these other people will. So you need to get those people on your team and involved in helping you facilitate the end result that you need for this kid. And they often will come to you. If you just tell mom and dad, hey, can you tell anybody that's interested in Billy's situation to give me a call or shoot me an email? And you'll get bombarded with stuff. You know, random neighbors, the guy who used to be a Sunday school teacher, basketball coaches, all those people will let you know if your juvenile has a lot of redeeming qualities, which we know they do because they're children, and give you some information that you can take to the state and say, look, I know what happened here was bad, but this is a really good kid. Here's all the people who think so. And that helps you navigate to a better outcome, ultimately. And all this is obviously premised on if your child actually committed this crime. If you didn't commit this crime, don't do any of these things. Just take it straight to trial. No, don't do that. Again, sometimes family are very, very conflicted about the juvenile's responsibility and culpability, whether you're doing a good job, whether they like your psychologist, whether your expert, the school records might be wrong. The school set this up. It's not this kid's fault. It's so-and-so's fault that they started hanging around with 2 years ago. So you need to figure out who's going to say what, and then figure out how to manage all these people and get them together. We often have team meetings in our conference room in our office, which sometimes are scheduled for an hour and turn into 4. Because we are navigating mom and dad's affair from 1978 that mom is still mad about and she's not gonna let it go. And then the sister who's mad because dad left, like all kinds of things. But we get through it all so we can ultimately figure out what we need to do to help this young person. And that sometimes you have to suffer through a lot of those conversations before you get to where you figure out what it is everybody wants to see happen for this young person. And sometimes that's all it takes for a child to know that you're really, really fighting for them and in their corner, is to know that you just spent 4 hours in a room with his mom and dad at the same time, because that's something that he's not willing to do. So sometimes that is all you need to get your kid on your side. You've heard a lot about juvenile court today. First degree murder charges. I, again, cannot wait to see one get resolved in district court. I can't wait. I think that'll be the most exciting thing ever. I don't see it ever happening. But if it does, please make sure y'all let us all know. Those of us that have been in juvenile delinquency court, we know how it goes. Think about it. You're doing an adjudication. Juvenile admits to something, ridiculous, a larceny, and disposition. And the judge says, Mom, is there anything you want to add? And mom's sitting behind you and she stands up and she tells you all the things he's done wrong in the past month that you said, please don't talk to the judge. Please don't tell the judge anything. And she said, last night at 2 a.m. I got up and he wasn't there. You're like, no. But all those things happen in district court. That's not going to happen in superior court. These parents and collaterals need to know the superior court judge does not care what you think. They're not going to ask mama for any information. They don't care. Oh, so sad that you're having trouble with it. Your problem. Superior court judge is going to make mama sit 2 rows back. If she starts crying, she's got to leave. We're not listening to that. Don't say anything. Don't get out of hand, or you will not be allowed back in the courthouse. I had a mama for a grown person get banished from the courtroom the other day because she cried quietly. Well, okay. But they do not get to provide any input. Superior court judges generally do not care what the family thinks. So it is your job to get that evidence in front of you. It's your job to make those arguments that hopefully are beneficial to this child. Say all the things that mama would normally say, he generally follows the rules at home. He's doing good in school, making good grades. He wanted to be, a welder or whatever good things that mom would normally say. It's now up to you in superior court to get those things out, get the judge to look at this child as a child and not just as a defendant. Don't let the court call your child Mr. or Mrs. anybody, their child, their children, call them such. I know y'all, that gets ingrained in us a lot in juvenile trainings. Children, they're not juveniles, they're children. The huge difference in Superior Court than juvenile court, because Superior Court is not a court of services. They are not looking to help your client. That is not what a Superior Court judge's role is. He is looking to punish your client. He is looking to teach your client a lesson. Make sure the community is safe and let the victims be heard. That is what Superior Court judges are most interested in. They're elected officials. So obviously when the victim's family comes into the courtroom, they're going to get 2 hours to sob and scream at your client from a podium. And your job is to sit there and take it. And that's hard. Because at the end of the day, you know what this child needs is therapy. Probably intensive therapy. Probably some good, sometimes some really good medication from a psychiatrist. Needs structure, guidance, all the things that the juvenile court is designed to provide for young people. That's what your young person needs. And now we're in Superior Court, and a Superior Court judge generally knows nothing about what happens in district court, knows nothing about what happens in juvenile delinquency court, and is not interested in providing services. They're interested in locking this young person up who's done this horrible thing, according to them, to keep the community safe, because that's what elected officials do, what the public wants. And that's what they're going to do. They're going to put your child in prison for as long as it's going to take to satisfy the victim's family. So think about those things when you're entering open pleas or saying, okay, we'll plead to second up to the judge, because the judge is going to give your child the most. I mean, odds are. Now I will say this, we have some new Superior Court judges across the state that just got sworn in earlier. I talked to one of them in depth. I know him personally. I'm not going to call his name, but he is very excited about discretionary transfers, because he says that's the worst thing they can do is let me have some discretion. I'm going to use it. And I said, well, I hope that's beneficial to children. And he said, children should not be in adult court. And I was like, I'm done. You win. I'm going to campaign for you next time. Sure. But a lot of Superior Court judges, especially older ones, do not feel the same way, because they came up in the era before raised the age. 16 and 17-year-olds were adults. So when you start presenting a 15-year-old, it's got a first-degree murder charge, that's an adult in that judge's mind. He's an adult. He did an adult thing. He needs to be punished like an adult. And we have to tailor everything we do to keep the fact that this is a child at the forefront of a Superior Court judge, because they don't. The biggest difference between Superior Court and District Court that your juvenile needs to understand is it's not a judge. It's a jury that's going to make that decision if you let them. 12 people who do not understand jury instructions, they don't listen to them most of the time. They definitely don't know what they mean. They have no idea what reasonable doubt is, even though prosecutors almost exclusively start their jury selection by telling you what reasonable doubt is. And then they just glaze over it for the whole rest of the trial, and then they end and at closing. Reasonable doubt, it's just not a thing here. You have to explain that to a child. That reasonable doubt on paper sounds really easy because there's a doubt. I mean, there's always an option that it could have been someone else, but a jury is very rarely going to go that way. And it's hard to explain that to a child. But someone once told me, if you win a case in Superior Court ever with a not guilty or hung jury, you should have a party, because it is designed for you to lose. 95% of the time, the state should win, because the state has all the resources to make sure they win. They have all of law enforcement. They have all the courtroom stuff. They have everybody. And you have what you have in your office what IDS, gives you funding for, and you, and a child. So remember that when you start telling them about you're leaving your fate in the hands of 12 people who don't know what's happening. They don't know. Superior Court judges versus district court judges. Y'all can tell I really love Superior Court judges right now. District court judges generally are on the bench and do all these things. They do abuse and neglect, they do juvenile delinquency, they do custody cases. So except for criminal district court, most of their job revolves around children and what's best for children, whether it's in custody, whether it's in abuse and neglect and DSS court. So they're constantly thinking about what's in the best interest of this child. I don't know if they can't turn that off, if that's their mentality for everything they do, which generally is a good thing, but Superior Court judges have never, they don't have any opportunity. It's never a case that's before them where they're thinking, what's in the best interest of this young person? That it unfortunately is not something they get an opportunity to think about or do or act on. So it puts them in a position where that's not when you say that to them, we need to provide services for this juvenile. A Superior Court judge does not, there's no services. They're gonna go to prison, they can get a GED. That's the service that they're gonna get from the Department of Adult Corrections. Whereas a district court judge, especially some that have been around for a long time, are very touchy-feely. They want to give them all the services. They'll come down off the bench and give these children hugs. Those are the people you want making these decisions for these kids. The ones that love them and are like, you want to come up here and let me show you how the bench works? And you're like, what? No, but it happens, and we have judges that are that way, and that's great. But Superior Court judges are not going to be that way. So anything we can do to convey to a child that sweet lady who, you know, when you were in DSS custody, when you were 4, that let you sit on her lap and bang on the gavel, that is not the same person that you're about to encounter. You're going to encounter a man who is 60 some years old, loves wearing that robe, and really likes having some power. And he's going to unleash that wrath upon you. You sweet child who maybe made it terrible, you are going to be punished. And kids don't understand that. So there's a way to kind of help them understand that. And this is what I recommend. Now, this takes a lot of effort if you have a child in custody. Have a court counselor bring a juvenile to court from a detention center. Let them come sit in Superior Court and watch. Watch somebody get sentenced. Watch someone who is a level 5 with a habitual felon indictment, who's here on a nothing H felony, get 7 years. Let them see that. Let them see that that's what happens, because they will be stunned by how severe and harsh punishment is doled out in Superior Court. And it's good for them to see that. If you can get them in there for a trial, I love to watch a trial. I've watched John Basinger try more cases than probably I've watched anybody, but to Miss Charles, good job, John. Watching the jury, watch the defendant is, you probably learn more about things watching those, especially when it's not your client that's on. You can just sit and kind of observe. You can see the just sheer disdain on some of them's face with the fact that there's somebody here that's been charged with such an awful crime. And then sometimes you'll see some look at them with that sweet grandmotherly look, like, just want to hug him. And then you have the people who are completely disinterested, but they need to see that there are all these kinds of people that are going to be on their jury. I'll say this, and I think I get into this in the next couple slides. If your young person is a person of color, which I think the statistics are pretty clear, almost all of them are, they need to see a jury pool from their county, which is going to have, you know, less than 2% people of color in that jury pool. That's their peers. These 45 and 50-year-old white folks who are housewives or retired or school teachers, that is the jury of their peers that's going to be judging them. That is never a good thing. And they need to see how important it is. One, how they're going to be perceived by a jury, what a jury's going to look at them and think, what that jury's going to look like compared to them. All those are things that are going to happen, and you don't get to experience them until you're in trial if you don't take them and let them see that. Go over the courtroom rules. Explain when, this is going to, y'all are laughing. Tell the child when they can go to the bathroom. Because it's not just in the middle of everything. It's, you just can't get up and walk out. But more than one, I gotta go right now. Sorry, we just had a recess. No, but they will not understand if you don't say, you need to go before we get in here. You need to look like this. You need to do this. I need you. All those things that are going to happen in the courtroom that juveniles, it doesn't happen in district courts. District courts say, hey, I'm gonna need 2 minutes, Your Honor. And they're gonna be like, okay, sure. And your kid can go to the bathroom, you come back, you're fine. Superior Court judge is not stopping everything. You got a court reporter typing, she's gonna have to explain why we're taking 2 minutes for somebody to go to the restroom. So those things do not happen in Superior Court. Provide a layout of the courtroom, make sure your child knows who everybody is, who's friend and who's foe in a courtroom. A bailiff who sits very close to them, although he's a charming man and we all love him, is not the person for you to talk to about what's going on in your case while we're trying it. Don't. He's not your friend. Don't do that. So if your client has nervous energy, which a ton of young people have, ADHD, I'm married to one of those people with ADHD, give him something to write on, to do something. Rubber bands. You'd be shocked how many times I've seen a rubber band wrapped around a pen 100 times and then unwrapped, but it gives them something to do so they're not fidgeting. If you look nervous, you look guilty. Make sure they understand that. I have a section on here for juvenile jury instructions, which some states actually have juvenile specific jury instructions. North Carolina's not one of them, of course, but you do need to know what you need to ask the judge for. And you're going to ask the judge for certain instructions based on what your evidence is. So I'm sure you all have heard a lot today about experts. Now, get the instructions you want, you've got to use your experts. You have to have a psychologist. You need some people in that witness stand talking about brain development, talking about how different it is because your client is a child. Once you get some testimony in the record in front of the jury about that, it's not that huge of a leap to ask the judge to give some instructions based on what you've provided as far as evidence. Make sure you have your young person's school records. I mean, they touched on that. School records, experts, medical records. I'm saying use the experts every 3 slides. Like it's the most important thing. Get an expert very early. Like especially with first degree murder, which is true of any kind of murder, but get your expert, like you finish your custody, walk back to your office and start finding one. Like see who can do it for you because that's what you're gonna have to have. North Carolina's pattern jury instructions are available online through the school of government, as all of us probably know. Look at those. Look at everything the state could ever possibly ask for based on what's been alleged. And then you have to figure out, one, how to tailor your case around those. Obviously, what can you chip away at as far as that? But the jury instruction for intent, as every first degree murder has an intent element, specific intent, requires a reasonably prudent person. It says, you arrive at intent of a person by such just and reasonable deductions from the circumstances proven as a reasonably prudent person would ordinarily draw therefrom. So we've heard about NRAGE JVD, which is looking at things from the juvenile's perspective. That is a really good case to try to get the judge convinced that he needs to insert a reasonably prudent juvenile or child in that situation, because that is, you can apply that case to anything that's happening with your child. Anything. It's not just about custodial interrogations. It's not just about trying to suppress stuff. Everything that happens to a juvenile, you can apply that lens, look at it through the eyes of a child, and try to get the judge to make the jury look at it, not just from the eyes of a child, but from the eyes of your child. But at minimum, a reasonably prudent child, which very often there's no such thing as a reasonable child. But ask for those instructions. But to get those, you're going to have to get some evidence in the record that helps support your argument that this child is different. He's different than an adult. He's different than any other child. Now, I look out around our room. I see some people of color here that are attorneys. Yay. Here's the hard part of our job. And that is, for most of us, raising race as an issue for a juvenile, it feels unnatural for the average attorney that represents everybody, and those of us that are, super liberal, and we know that the statistics are awful and that kids of color are charged way more than any other kids. The numbers are horrifying when you look at it. But you can use those numbers because you need to be raising race at every opportunity. And you can do it without being the person who's standing on your soapbox saying, this wouldn't have happened if my client wasn't a Black kid. You can do it without doing it that way. You have to practice it, but there are lots of statistics that help you. Here are some. This is juvenile statistics. How many juveniles get charged? How many juveniles are in detention? How many juveniles are in YDC? All those things based on the population in their county. And that's what's kind of scary when you think that the population of a county is 20% people of color, but 85% of the juveniles in custody are juveniles of color. You can do it in motions practice, suppression motions. You can challenge any identification of your young person. You think about it, you have a young person of color charged with first-degree murder. Think about who the witnesses are. Look through and see. Are these people of color or are they white people? Show-ups, lineups, in-court identifications, all these things can be tainted by who is making these identifications. And there's obviously, we all have seen cross-racial identification issues in the courts. And there's been cases all over this country that have been, people have been exonerated for being identified incorrectly based on a cross-racial identification. There's also explicit bias, which I didn't think was so great of an avenue until here recently, when we've seen so much law enforcement get charged and fired for putting hate speech on their social media. I didn't know law enforcement could be so ridiculous and dumb, but they do it. They put some of the most atrocious hate speech on their social media, and all you have to do is look for it. You just need to look, search. Who's your officer? Who's the school resource officer? Who are your witnesses? Check out every single person that's involved in your case to see if there's anything there, because you will be surprised the things people just, we're baffled when juveniles put stuff on Snapchat with them holding a gun. Cops are just as dumb sometimes. They do insane things. And even your prosecutors. Check your prosecutor. See if they have anything in their closet. Generally, if you're in a small town, if there's something in their closet, you know about it. But if it's somebody from the Conference of the DA, somebody special that's coming to do it, you may not know that person. So you need to do just a quick search, Snapchat, TikTok, all those things. And see if there's anything that would be an explicit bias that you could bring up to the court. Interpretation, this would go to self-defense type arguments, an unreasonable interpretation of threats. This study, those of us that went to JTIP, some of us, learned a lot about this. Generally speaking, people of color, especially young men of color, are perceived to be more threatening than any other people, any other group of people. A 15-year-old African-American child is perceived to be more intimidating and more threatening than a 40-year-old Caucasian man with a knife. That's mind-blowing to me, but it's a thing. So there's tons of research on that, and there's tons of literature that you can use. If that's the case, if this happened because there was a fight and somebody perceived some level of threat, you can use that information to help paint the picture of what your child was thinking when this incident happened. There are tons of ways to bring up race that aren't super awkward and sound weird. The majority of our Superior Court judges and prosecutors, at least in my district, are all regular, good old boy white men, and that's fine. You know, all of us have our problems with that. Sometimes you got the people that refer to you as little lady if you're a girl, which is always nice, or young lady, which I like better than little lady. But you have those kinds of people that are involved in it that don't even realize the way they are. They have that just inherently inside of them. And until you pull it out of them and say, well, Your Honor, if it wasn't for this, this wouldn't have happened. Or let's look at why every single child that comes through here that's transferred to Superior Court is a child of color. Why is that the case? Why is this white kid getting a diversion contract when this other kid is getting sent to court? And those are issues that happen in every juvenile jurisdiction in this state. I know no court wants to be the one that owns it, but I've been practicing in Forsyth County for two years. Is that right? 2 years. And I have yet to see a white juvenile charged with a crime in that courtroom. 2 years, twice a week. Never seen a white kid. So I asked the question. It's all white kids. They don't do anything over here. What's happening? I'm never divert those. We divert those. So if you don't bring it up, ask the question, point it out, you never know. I didn't never dream that was going to be the answer I got. I was just going to be like, I'm sure. I thought I'd get some, look at the numbers, but no, it's like we divert those. Okay, well, that's I think the wrong answer, but bring it up. Bring up the things that you know are factors. Make sure your children understand all these things you're saying and all the things you're doing behind the scenes, because at the end of the day, if your child understands that all this is working towards that positive result, what they want, they will give you all the information and all the help that they can. But they will tell their families to give you all the information and all the help that they can to help resolve this case. And at the end of the day, we want children to be at home, parents where they belong. Children should not be in prison. I personally don't like children being in YDC, but I understand sometimes that is where it is. But these kids need to be in a home-like environment with people who love them and support them. And that's how we make them better adults.